Good morning, Your Honor.
Good morning, Your Honor.
Mr. Durso, good morning. Mr. Valle, good morning. If you, either you gentlemen want to sit down?
Yes, thank you for that.
Yes.
Thank you, Judge.
You're welcome. One housekeeping matter. You can sit down, sir. One housekeeping matter before we begin, Mr. Valle. Mr. Crossland, I know you informed myself and the state that you were going to use a PowerPoint presentation in connection with your argument. That has to be marked as a full exhibit. So in the event a reviewing court wants to take a look at the arguments today, they will have everything that we have. So what I'm going to do is I'm going to have this marked as defense 1. This was the court's courtesy copy. And I would say within 2 weeks, by June 15th, if you can get the clerk's office, what is it, a compatible CD?
Yes, Your Honor. Flash drive.
A flash drive? Can you do that inside of 2 weeks?
I can do that, absolutely.
So that's the order of the court. This will be marked as defendants 1, and if you can return it to me as soon as it's marked.
Would Mr. Clerk prefer the email as well, or just the flash drive?
Physical will be best.
Okay.
All right, Attorney Crossland, you filed a motion to dismiss on certain grounds. Also, a follow-up memorandum that I received last evening. So it's your motion, sir. What would you like to say in connection with your motion?
Yes, Your Honor, thank you. I did, for the record, supply a response to the state's response. I know I have the burden, so I just reserved, I guess, 2 minutes after the state puts on their response. But I did file a written response as well. Thank you.
I have, the court has 2. I have one dated April 15, 2026. And I have one dated May 31, 2026. And I also have the state's memorandum. So I don't know which memorandum you want to argue off of, or if you want to go coming back. I'll allow you to determine the order that you want to proceed. But there is a threshold issue. One threshold issue. I know the grounds that you've mentioned. But there's a threshold issue with respect to, is the state's amended information, amended complaint, is it properly before the court? I don't know if you are going to concede jurisdiction, argue jurisdiction. There certainly is an idea out there that it affects subject matter jurisdiction. So I don't know if you want to argue that, but it is a threshold requirement in my mind.
Yes, Your Honor, and I don't think the state meets that burden. What I did was, in the PowerPoint, I put the original, my original motion as well as my response. I combined it using the state's authority, Chistero and other authorities that they had in their response. So I put them both together, so I can just argue as one.
Okay, but I don't think that's a burden issue. This is a procedural issue of an amended information that was filed to our clerk's office who accepted it. Listen, it's your election whether you want to argue that or not. I just know that it has to be addressed.
Yes, Your Honor, and I would say to the court that the written submissions that I made articulate that I think the information that was amended is improper and the court should accept it. So I don't think this court has jurisdiction, again, to try this case again. And I want to be clear with that now. That's the breadth that I'm using. They do not have jurisdiction. So I think that's articulated in there, and I'll say it on the record openly that we object to the amended complaint, and we object to them going forward with the retrial based on
The retrial is a much different issue. We'll get to that. I know you want to get to that. I'm just speaking of the threshold issue of the procedural filing of the amended complaint.
which we object.
And what's your ground for the objection?
The grounds for the, I can submit something in writing, but obviously the grounds for the objection is that when Judge Murphy made her ruling, the ruling necessarily encompassed exactly what's in the amended complaint. The amended complaint appears to me to be a repackaging of the same issues, the same charges that the jury has already spoken on. And so again, without belaboring the point, I didn't submit a brief specifically on that because
I think counsel's a little confused, Your Honor. I think the court's question is whether or not this court has subject matter jurisdiction over the issue before it, is the question that the court's asking, unless I'm confused.
If it's properly before the court, I have jurisdiction to hear the motion to dismiss argument based on collateral estoppel.
Correct.
If it's not properly before the court, I do not have subject matter jurisdiction to hear that argument or anything else connected to this.
so with that being said, obviously, counsel articulated whether the court has jurisdiction over the issue. And so the issue is not what's in the plethora of documents that I've submitted. The issue is just whether the court, who knows the file and knows the case, would make a ruling right now that it has no jurisdiction and then we go home. So I think that's where we are now. My position is that the state has no subject matter. The court has no subject matter jurisdiction because the issue is res judicata. The jury has ruled, and I think that's as plain as day. And if the court makes a ruling now, then we don't have to even go forward.
I kind of know two things that way. I hear you, I hear the state. I do a thorough analysis based on the arguments presented before it. But I now have your objection, which is res judicata or something similar to res judicata. Prevents the case from going forward for the reasons that you stated. Mr. Gersa.
The state believes this court does have subject matter jurisdiction to listen to arguments of counsel at this point in time with regards to the defense motion to dismiss. We would submit that this is proper before the court. The case is still pending. I think the counsel in his memorandum that he filed yesterday at 5:05 p.m. Indicated in that memorandum that the trial court's notified that the deadlock jury did not terminate jeopardy. The defendant never argued it did. So if he's conceding that point, that this is properly before this court in order to hear a motion to dismiss. If he's arguing that this is not proper before this court, then that's a separate argument that we need to have, I guess. But I think it is proper before the court. I think the defendant concedes that in his memorandum.
All right, just briefly, that's a misstatement. I think the memorandum says that the state's contention is that when a jury deadlocks, can the state go forward unless they're included? And what memorandum made clear is that obviously, yes, we all, as lawyers, we know that if the jury deadlocks on a top charge, but there's less included, we can go forward, but it must meet thresholds. And the state now has not met that threshold to go forward. So the general question as to whether you can go forward on less included, the answer is yes, but it has to meet thresholds. And I argue that.
That's a separate argument.
That's the same.
That's a separate argument with regards to subject matter jurisdiction.
Can we do one at a time? I know counsel is passionate, and I don't want to get that passionate because then you won't be able to hear it. The record won't pick up. So what I'm saying to you is, counsel saying I conceded to jurisdiction based on an argument that he just made. First of all, that's not my argument, and that's not a concession. The argument was there's no argument that you can go forward unless included if the jury deadlocks on a top charge, but you must meet thresholds. And I'm going to argue those in a minute, what those mean. So that's not a concession.
Listen, I'm not going to deprive you of your ability to argue. Subject matter jurisdiction could be raised at any time, including well past this matter, well past any trial. That's why I believe it's a threshold issue that I will address in a written decision. You've given me your position on it, and the state has given me its position on it. So now let's move into the second phase of the hearing, which is the items that you filed in connection with your motion to dismiss.
Thank you, Justice. Your Honor, on May 14, 2022, a 16-year-old Raul Valle, who sits next to me, attended a house party in Shelton, Connecticut. During that gathering, a violent confrontation erupted involving multiple individuals. Mr. Valle has consistently maintained that he was surrounded and feared for his life, and that his use of force was a lawful act of self-defense under Connecticut General Statute Section 53A-19. At trial, Mr. Valle testified that he felt terrified and surrounded. His self-defense claim was the central and dispositive defense theory presented to that jury. The state subsequently after that party, charged Mr. Valle with murder under Connecticut General Statute 53A, 54AA, in the death of James McGrath. They charged him with 3 counts of assault in the first degree under Connecticut General Statute 53A, 59A1, intentional first degree assault for the stabbing of Ryan Hines, Thomas Connery Jr., and Faison Teal. The formal information also included lesser included offenses. After a full trial in Milford Superior Court on July 25th, the jury returned unanimous acquittals on murder and all 3 counts of intentional first degree assault, the primary charges in the formal information. Now, Judge, the jury did deadlock on lesser included offenses: first degree reckless manslaughter under Section 53A, 55A3 as to McGrath, reckless first degree assault 53A, 59A3 as to Hines and Connery, and reckless second degree assault 53A, 60 (A) as to Teal. Judge Sherry A. Murphy declared a mistrial on those deadlock counts and released Mr. Valle on the existing $2 million bond without new conditions. The state subsequently filed the pending amended information, which we just spoke about, and which we object to, which mirrors precisely the 4 deadlock lesser counts. Now, the jury instructions, page 50, under self-defense, I'll get into in a second. Can you articulate means? I'm not sure. I'm needing to be by a mic. Okay, thank you. Your Honor,
motion to dismiss has now been filed on behalf of Raul Valle, and it is one of the more precise, disciplined constitutional filings you will see in a case like this. It does not hedge. It does not wander. It targets a single issue and builds around it with control. The state does not get to try this case again. This is not rhetoric. It is a structured legal argument that ties together double jeopardy, collateral estoppel, and Connecticut law in a way that forces the court to confront the same question from multiple angles. Start with what cannot be disputed. In July 2025, a jury returned not guilty verdicts on murder, 3 counts of intentional first-degree assault. Those were the central charges. The same jury deadlocked on lesser counts framed as reckless conduct, and a mistrial was declared on those counts. The state then refiled those same lesser charges. The defense's position is straightforward. The Constitution does not allow the state to do that under these facts.
now, on July 9, 2025, the jury spoke. On the left-hand side, you hear, you see unanimously acquitted on murder as to McGrath, intentional manslaughter first as to McGrath, intentional assault first as to Hines, intentional assault first as to Connery, intentional assault second as to Teal. On the right-hand side in red, the reckless manslaughter first as to McGrath, the jury deadlocked. Reckless assault first as to Hines, the jury deadlocked. Reckless assault first as to Connery, the jury deadlocked. Reckless assault second to Teal, the jury deadlocked. Now, what the Constitution doesn't allow us to do is to go into the jury room and question as to why they deadlocked. The jury, we could imagine, the jury may have thought that Mr. Valle's actions were not reckless. We can pontificate or guess or speculate as to what they were thinking, but the Constitution doesn't allow that. Same act, same night, same individuals. As we talked about the state's authority in Chestero, you must have something different, other elements, and Chestero breaks that down. But here we have the same act, the same night, same individuals, so we cannot have a new trial based on these facts. Now, framing the issue, the state is answering the wrong question. The state's question, does a hung jury permit retrial? That's what we just talked about. The answer is clearly yes. We have that all through the United States. But the real question is, did the acquittals necessarily decide justification? And the answer is yes. Yeager bars litigation because justification was used in the first, and if we were to go to trial this afternoon at 3 o'clock, after lunch, my client would be saying that he was justified, he would be saying that he was defending himself, and the state would be arguing that same point because the burden is on the state then to prove that it wasn't justified. They failed to do so in the first trial, and they'll be trying to now try again to say they were justified. And that's exactly what the Constitution wants to avoid, that they get a retry to show that my client wasn't justified when they already got a chance and that came back. as that my client was justified based on the verdict. Now, on the Yeager versus United States, 557 United States 110, a 2009 case, they quote, "The hung counts are what they call a non-event. The consideration of hung counts has no place in the issue preclusion analysis." The state cites Yeager in their authority. Then they do the exact thing that Yeager prohibits. So they cite it, and then they violate it.
How did they violate Yeager?
They violated Yeager because Yeager looks at whether there was issue preclusion. If the issue is justification and whether they have the burden of proving that my client was not justified, they failed to do that, then Yeager said you can't now go back and...
How do you know the jury determined they failed to do that? Because I can tell you what Yeager does say. Yeager says, the jury's deliberations are secret and not subject to outside examination. So you are performing outside examination right now, certainly suggesting, if not more, that the state somehow failed its burden to disprove justification. I need to know how you know that the jury actually discussed self-defense.
That's a good question. And Judge, what I do... Yeah, exactly. And what I do, I apply the reason and rationality basis that the Supreme Court also cites, and I'm going to get to that. There's reason and rationality that when the court gave the jury instructions on page 50, the court says, if you find that the state has proved beyond a reasonable doubt each and every element of a crime to which self-defense, defense of others may apply, you must go on to consider whether or not the defendant acted in self-defense. So the jury had to look at each and every element of even the crimes that they acquitted on, as well as the other ones. And so I go on to highlight the reason.
But isn't there the possibility, and again, I don't know, I'm never going to know. Isn't there the possibility that when the jury deliberated, they never reached the issue of self-defense because they determined the state did not carry its burden of proving intentional conduct beyond a reasonable doubt, and that's why they issued acquittal? Isn't that possible?
Well, as they always say, anything's possible. What's probable is under the reason and rationality test is that when you look at the facts here and you see a person who's wielding a knife at someone, that the only intent they could have is in defending themselves is to cause bodily harm. And if you do so, you can't say that the person now who was wielding the knife in defense of themselves, who brought about these consequences, didn't have that intent.
But in the charge conference, did they discuss a reason and rationality test?
In the charge conference?
Yeah. That's what you're using as the criteria for the issue that I've raised under Yeager, which is the outside examination of jury deliberations.
So it's not a criteria. I think the way the Supreme Court looks at it is they say that you can't look at the draconian, I think the word is, I forget, I'll get to it in a second, but you can't look at a draconian, hyper-technical analysis and say that, oh, well, the jury may have not got self-defense, but, man, and they talk about how you apply that. So I think you have to apply that as a whole. And so obviously the idea here is if the person says, I intended to do this, right? I intended to do this, and I did it because of this, and they apply that to the elements, then we get to these hung charges. And as you said, we can't know what they're thinking.
But why are we applying anything to the jury deliberations? The case you cited, Yeager versus United States, 557 U.S. 110, said the jury's deliberations are secret and not subject to outside examination. That's not, you're arguing somehow that the jury had to have found that Mr. Valle's conduct was excused because of the justification defense, as you put it, or self-defense. How do we make that leap if we're not allowed to conduct outside examination of their verdicts?
And respectfully, what I said was that if we are going, none of us can go into that room and guess what they said. I said they could have very well...
We can't even guess what they said now.
Right. I said they could have very well said there was no recklessness. They could have very well said that there was self-defense. We can't go in and guess that. And so I think the jury verdict stands. And the question is, to a court of competent jurisdiction, looking at the hung charges, the court has to then make a determination, how do we proceed? Can this prosecution now prosecute again? And that's where the legal analysis comes in. And so that's the rub. So you're right, we can't guess, but we have to do
I
something.
agree with you on that. I do agree with you on that, sir. But if you and I do have an agreement on that, I'm not sure Yeager is the proper authority for it, because Yeager is very clear. We don't examine jury's deliberations or verdicts.
And Judge,
That's conjecture, guesswork. That is about as sacred as it gets on the criminal law side of our documents.
and 100%, I was before the appellate court a couple months ago, 3 hot bench, and I can tell you that I think we have to look as intellects, we have to look at the total picture and decide how do we get to where I'm arguing we should be. And if not, obviously the appellate court looks at that and say, but I think the Supreme Court precedents that say this case cannot be tried, even above and beyond Yeager. So look at going beyond Yeager. Look at Chestero. Chestero was, I think, cited in the state's response. That's 197 Federal 3rd, a 1999 case, and that's the state's lead case. That's the case that they relied on as their lead authority. That's their case, and it's their case, it's their test, and we still win that analysis. Chestero rule. Retrial is barred where the acquittal necessarily determined in the defendant's favor an issue that would be an element of the offense at retrial. And that's very clear. And that's their case, and the Supreme Court is very clear with that. In Chestero, a retrial was allowed. And I think that's what the state got a little intoxicated on, because they saw that in Chestero it was allowed. But it's not just allowed blanket. It was allowed in Chestero. The acquittal turned on the weapon/injury element only. It decided nothing about the lesser elements. And that's why in Chestero the court allowed them to have a retrial. In this case, the retrial is barred. The acquittal is necessarily decided justification. The identical fact the state must disprove on every reckless count. So if we move forward, unlike Chestero, the state's going to then be faced again whether this was justified, and that's why it's barred.
But do they even get to it? Do they reach that? The jury instruction state and instruct that you first have to establish that the state has carried its burden beyond a reasonable doubt of all the elements of the crime. If they make that finding, then they can pivot over to justifiable self-defense. If they do not find that the state has carried its burden beyond a reasonable doubt, do they even get to self-defense?
Page 51 of Judge Murphy's instructions states quite clearly under the state's burden, when evidence of self-defense/defense of others is introduced at trial, the state, in order to obtain a conviction, must prove beyond a reasonable doubt both elements of the crime charged and that the defendant did not act in self-defense. It goes on to say at page 51, if the state fails to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, you must find the defendant not guilty, despite the fact that you have found the elements of the charged crime proved beyond a reasonable doubt. So I think when you apply the reason and rationality approach, the jury goes back. They heard the entire case. They heard self-defense. They looked at all the elements of the crime charge. So if somebody's charged with murder, you cannot be found not guilty of intentionally doing something, and I'll go into this, because you intentionally stabbed someone. So you can't be found not guilty of you can't have a consistent verdict where they say you're not guilty of intentionally doing something, but you're guilty of recklessly doing it. That doesn't sound in logic. So if you intentionally do something and they say not guilty, you can only conclude that when they apply the elements, justification wasn't disproved, I should say, by the state. So they found not guilty of murder. Then they can't come back and say you're not guilty of intentionally doing something, but you're guilty of recklessly doing it.
What if they found that the state hasn't carried its burden in the first part? We don't know if they did or not.
And
We're never going to know.
And there lies the problem. You have to look at the state of the record. And again, the court may conclude differently, but I'm saying the state of the record shows that he intentionally did this. All through the trial, he said, I did this.
No, the state of the record shows acquittal, 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 acquittal. That's the state of the record.
That's the state of the verdict. But the state of the record is what defense that Mr. Valle say in that trial. He says, I did this intentionally because of this reason. And then we have the acquittals.
But what if the jury did not find merit in that? Or what if they did? We don't know. How are you supposed to know that? We don't sit as a 13th juror. You, Mr. Durso, or myself.
Well, it's funny, I have an appeal pending in federal court, and the judge can't sit in 13th juror under certain case law.
Well, good luck in that in federal court, but we're here in Little Milford Superior Court, so...
And so, Judge, that's my position, obviously, that you can't do something intentionally and be liable for it recklessly. You can't be acquitted for doing it intentionally, but say, oh, we can hold you liable
That's
for
a
recklessly.
whole different argument that I'm confident when the state has its opportunity. I'm not going to put words in Mr. Durso's mouth because I don't have to, but I assume somewhere we're going to hear some argument on the difference between reckless conduct and intentional conduct.
Yes, sir. So, anticipating this type of colloquy, I decided to take something, one of the charges that I think crystallizes this more clearly. And I think that same teal, I call it teal sponge. You can take that teal sponge and use it. So using the teal sponge, the dispositive anchor looks at count 4. Count 4 was the teal acquittal. Intentional assault second, 53A, 60, paren A, paren 2. Elements. Intent to cause physical injury, we just talked about that. Number 2, cause injury to teal, yes, undisputed. And 3, by a dangerous instrument, right? Those are the elements. They have to prove beyond reasonable doubt in order to get to what they're trying to go. The stabbings were never contested. Mr. Valle did not dispute he stabbed Teal with a knife. Number 1, clearly undisputed. Using the same teal sponge, we go to number 2. Intent to cause physical injury by stabbing cannot be rationally denied. You stab someone with a knife, you intend to cause injury. The question is whether it's justified. And that can't be rationally denied. No jury finds a person who stabs another with a knife lacked the intent to cause physical injury. That's just illogical.
What if, and this is not the facts, as I understand them, at least at this juncture, what if a person was involved in an assault using a knife, but was entirely intoxicated? Now, I'm not saying that that's not the Valle case. What if that person wielding the knife was entirely intoxicated, and tox results prove that, which would strip that person of the intent? You're saying that a jury can't find that?
Oh, okay. So I can speak to that because I've had cases like this.
Cases.
Right.
I'm reading where it says, no jury finds a person who stabs another with a knife lacked intent. I think the example I just gave you might give the jury an opportunity to say that person lacked the intent because of the intoxication.
As a jurist, that's a proper analogy to make. However, as jurists as well, we know that intoxication may negate an intent, right? Because it goes to mental state.
But you're saying that can never happen. It doesn't say some juries. It doesn't say the Valle jury. It says no jury.
No jury in my state of mind, Judge. So obviously, I'm trying to respond to you as succinct as possible. And so, in this case, my position is quite clear that the stabbings were never contested in this case, right? We know that. The intent to cause physical injury by stabbing cannot be rationally denied. Mr. Valle stated on why he stabbed, and therefore this jury cannot find that he lacked intent because he said he intended. If that makes it a little easier.
It does, but what if, let's go to Valle now, forget my example about intoxication. What if the jury, after full and fair deliberation, found that Mr. Valle did not have the intent, and they acquitted him on that reason? I don't know if they did or not, I'll never know. But what if they did have that discussion and arrived at that conclusion?
And
You're
that's,
saying they can't, that the only rational basis based on reason and rationality, which candidly, I still don't know what that means yet, but that's what you're saying. That the only verdict they could have arrived at was based upon the state's failure to disprove self-defense, right? Because I read and I agree with you. Self-defense is a valid defense to intentional conduct. Self-defense is a valid defense to reckless conduct. You wrote that. I agree with you. But what you're saying, and I have highlighted in several places, the state failed to disprove that Mr. Valle's use of force was justified pursuant to Connecticut General Statutes 53A-19. And because self-defense is a valid self-defense to reckless conduct as well, the state cannot prosecute Mr. Valle any further. Isn't that your argument? Because that's on page 1 of your most recent memorandum.
that's my response, yes. And so obviously, the court's going to say again, and I would agree again, that obviously you can't go in the minds of an individual, such as a jury, to say exactly what they were exactly thinking or where they went. But when we look at mens rea, and in all criminal cases, we have a mens rea and an actus rea. We never really get a contract, even in conspiracy cases, that says what the agreement was. But we look at the behavior, and then we kind of infer. So if the jury has Mr. Valle at trial saying, I did this intentionally, then when you use that and you're rational, then say, if he says I did it intentionally, then they can't say he lacked intent because he told him he told him it was intentionally.
I wasn't in the trial room. I don't know if he testified that he
It's in the record.
intentionally. I don't know if he did or not. And even if he had, I'll give it to you, even if he had testified in that manner, I do not know how the jury processed that testimony.
And I think that still doesn't, and we can get down that road, that still doesn't give the state of Connecticut an opportunity to violate the Constitution and try someone again on the same elements. But good questions in terms of whether, in fact, we can go inside their mind. I'm applying the rational basis test, but you're applying.
Good phrase by you, though, the same elements.
Yes.
We'll see.
Thank you. The Teal acquittal rests on nothing but justification. That necessary decided fact is the identical issue the state must relitigate on the reckless count. And Ash versus Swenson, 397 is a United States Supreme Court case at page 436, 1970 case that speaks about that. So you cannot, on the identical issue, go and relitigate and get a second chance and repackage.
But again, that's, if we can go back to that other slide, this captures the court's concern in one sentence, and it was a sentence that Mr. Crossman has used in his presentation. The Teal acquittal rests on nothing but justification. A certain sentence that eliminates any other possibility of acquittal. And I just don't know how we can make that move.
So in response to that, Judge, I would say that if the court is at a dead stop in terms of not agreeing with this conclusion that I'm making based on Ash.
Well, Yeager says I can't.
And Ash says that obviously if the issue that the state's now trying to relitigate is identical to the issue below, they can't do it. The issue below, even moving away from what you think that we don't know, the jury might have been smack on with me, but we don't know, secret. But the issue below, we know, is that this man was in danger, and he articulated that, and that's why he acted in response to that danger, because he could have been stabbed, shot, etc. And you don't wait for that. You act in self-defense. And the jury said, not guilty, right? And so now I guess we're stuck here in this court again saying, why did they say not guilty? And
I'm not.
And and we don't
I'm
know.
not concerned about that.
You
I
say
just
they-
know that the man received acquittals, and we do not search, pry, probe, guess into how they arrived at that decision.
Right, and so I think that we look at the record and say that he was saying that he was defending himself. The state, according to our law, has the burden to prove that he was not justified. They failed to carry that burden. How do I know they failed to carry that burden? It's because the jury came back with acquittal, not guilty, on an intentional murder, an intentional act. He said, I did this. And any jury is going to say, you did this. And maybe there's some other reason. We just like your suit that day. But rationally, is he said, I intend to do it. The question is, were you justified in doing it? Not because you had a nice suit on. And if you don't kill someone, and the jury says, you can go home. But we don't know why. It may have just been the day. It's because the law says, and the jury section says, that they have to prove that he was not justified. And if they say...
No, they have to prove the elements of intentional conduct, is what they have to prove.
Well, that's if they want to get a guilty verdict beyond a reasonable doubt. But if they're saying that the defense of self-defense is not, they disagree with it, they have to prove that he was not justified. That's their burden. It's in the law, and that's their burden to prove. And if they fail to do so, that lets the jury say, okay, they failed to do that, and therefore we're going to acquit. But again, we don't know the nuances, but that's rational. Go to the Espinal case, 2008. That's a Connecticut appellate case at page 369. That's a 2021 case. Very, very recent case. The state cited the losing side. The state cites page 410. Juries could not have considered the lesser offenses if they acquitted on the basis of self-defense. That's what the state says. That is the defendant's appellant's losing argument. The Espinal court rejected it. The court held the instructions were adequate and upheld the exact same elements first / self-defense second structure as to Judge Murphy's Valle charge. So when you look at Espinal, I think the state gains no position even in Espinal. McElrath versus Georgia, 601 U.S. 87. That's a 2024 case on our doorsteps, very recent. Once rendered, a jury's verdict of acquittal is invalid. You cannot touch it. At page 94. Cases prohibit any speculation about the reasons for a jury's verdict, even when there are specific jury findings that provide a factual basis for such speculation. At 97. A hung count, Yeager says, is a non-event, provides even less basis. The state's inference is doubly forbidden. Now, I think that the idea is that we don't want to go into jury rooms, we don't want to question their verdicts, we don't want to even double think. And under this McGrath, McElrath case, it's a unanimous Supreme Court, United States Supreme Court case that says once rendered, the jury's verdict of acquittal is inviolate. Cannot question it.
But wasn't McElrath, the issue in McElrath was a jury determined that the defendant was not guilty by reason of insanity. And the issue was, can the state retry him based on that initial finding that he did not have the mental ability to go to trial? Though that's not even close to what we have here.
I'm not sure how course-martial on that. If the person...
I'll read right from McElrath, one sentence. For double jeopardy purposes, a jury's determination that a defendant is not guilty by reason of insanity is a conclusion that criminal culpability had not been established, just as much as any other form of acquittal. So McElrath had to deal with a defendant being found not guilty by reason of insanity and the state attempting to retry that defendant, which McElrath said you can't do. But insanity was never part of the Valle trial.
Yeah, but you see, I mean, I'll just address it. You see the difference there. Obviously, when you're found not guilty by reason of mental insanity, NGRI, and not guilty of mental insanity, the issue still believes that, well, if he wasn't mentally insane, his behavior might have been criminally liable. But this is not mitigated because it's actually it exonerates the person. But I think there's a distinction here. But the idea is that once the verdict is rendered, you can't touch it. Here, I don't think the state's trying to touch the verdict of acquittal, but they're trying to now retry the lesser charges, and they have to reach a certain verdict in order to...
Based on manifest necessity, which does not trigger double jeopardy or collateral estoppel.
Yeah, so I think there's a distinction. We do have collateral estoppel, and we do have double jeopardy, because collateral estoppel is a component of double jeopardy. And that's what we're saying. If you issue precluded, it's the same issue. Collateral estoppel is inside double jeopardy. It's a part of the makeup. It's in the soup. You go to State versus Williams, 352 Con 104. That's a 2025 Connecticut Supreme Court case. Self-defense bars the reckless charges. And that's what we talked about when I opened up, when we started talking this morning. Self-defense absolutely bars any coming back on reckless. And obviously that's what the state's trying to do. They're coming back on a reckless charge. 53A-119, justification is a complete defense to manslaughter and assault. The state bears the burden of disproving it beyond reasonable doubt. In Williams applied the rule even where the victim was an innocent bystander, not involved in the confrontation. And I read this, looked at this, and just being rational. And Williams, the person was an innocent bystander. And as they say in some fancy term at fortiori, if the defense protects a defendant who accidentally harms a bystander, it certainly must apply with even greater force where the alleged victim were the very persons Mr. Valle was defending himself from. And so again, just being pragmatic, in a self-defense claim where an innocent bystander is killed, it still applies. In this particular case, Mr. Valle is saying, I'm defending myself from the same people who are attacking me, and it should apply even with greater force. And
the principal issue in Williams was whether the trial court made a mistake in not giving the jury an instruction at all on self-defense. That was State versus Williams. In that case, the trial court gave no instruction at all in connection with self-defense. And you're asking me to cite with authority that appeal with what you're arguing today? The trial court gave the self-defense instruction. In fact, you read it into the record this morning.
Correct. And so what I'm saying to you, even in Williams, obviously when you pull a case, you pull it for a reason. In Williams, they talk about 53-19. And justification is a complete defense of manslaughter. And as I'm stating, that self-defense bars the reckless charges.
But the problem in Williams is they never instructed the jury on 53A-19. And you want me to use Williams as authority for your position? The trial court in this case issued an instruction on justification over and over again, I might add.
Right, I agree with that 100%. My only point in giving more than less, obviously you don't have to rely on Williams. A court relies on what they might feel persuasive and disregards the rest. And sometimes the dissent, in many cases, will take something that may not seem persuasive and argue an extrapolation from that. So I think that it was important for the court to look at. The self-defense comes up again, and that it's a complete bar even to reckless charges. Summary. The three independent bars to retrial. Any one of them requires a dismissal. All three demand it. Yeager, with the state's recent case of Chestero, the state cannot use the deadlock to infer no justification finding. Chestero's own test, their lead case, requires dismissal because justification is a necessary fact. The acquittal is decided. Count 4, using Ash. The Teal acquittal on intentional assault second can rest on nothing but justification.
Intent to cause physical injury by stabbing is not rationally deniable. The Ash standard is satisfied. And McElrath, the acquittals are invalid. Speculation is forbidden. Even when specific jury findings, a hung count is a non-event. Provides far less. The inference is doubly prohibited. Relief requested. I think the court, when you look at the state of the record, and I have the transcript, of course you get the transcript, this young man was 16 years old at the time, was fighting for his life, and he stands here years later, still under the same prosecution. And now the state is attempting to repackage the lesser included and then have the same trial again. I beg the court to apply the idea that if we were to try this case at 3 o'clock this afternoon, the exact same victims we brought up, the exact same defense we brought up, the exact same burden that the state had in the first trial will be used, and it will be Groundhog's Day, all over again, which the Constitution in seeking finality aims to avoid. Double jeopardy, collateral estoppel, Ash, Yeager, McElrath, the acquittals necessarily decided justification, an essential element to every pending case. Now, of course, if the court were to take another approach at this, the court will be inclined to have a whole evidentiary hearing on this. And as the court stated earlier, the court wasn't there. Maybe the court doesn't know the record as clear. But if we were to go beyond anything but dismissing this attempt to retry, the court would have to have that type of hearing. As I mentioned, it's been 4 years under this prosecution, 4 unanimous acquittals. Mr. Valle was a juvenile at the time of the incident, and these are the compelling circumstances the statute exists to address. Lastly, I point Ash again, Ash versus Swenson, 397, the United States case. I instruct the court to 436, page 466, 90 S 1189, 1970 case, and I take a quote. And this is what I was telling the court earlier in terms of how to approach this. The rule of collateral estoppel in criminal cases is not to be applied with the hyper-technical and archaic approach of a 19th century pleading book, but with realism and rationality. And I know the court said earlier that I think, and I don't want to misquote the court, that you don't really know what that means or you're grappling with that. This is a quote from Ash versus Swenson. And again, the rule of collateral estoppel, which I said is inside double jeopardy, in criminal cases is not to be applied with the hyper-technical and archaic approach of the 19th century pleading book, but with realism and rationality. And so when you look at this entire case, Judge, I think the jury spoke. Judge Murphy did a great job with...
Always does.
Yes, she always does. And she did a great job with putting together these jury instructions. And she did a great job with congratulating Mr. McGrath, Mr. Valle, and wishing him luck. He's been under this bond for 4 years.
We'll get to that in a minute, but I'm looking at the quote now that I see the full quote about realism and rationality. The rule of collateral estoppel should be considered with realism and rationality, but that's through the prism of you and your client. You are the one ascribing what the realism and rationality should be, right?
No, I think the rule of collateral estoppel and what Ash is saying is that any court, not me, my client, we don't apply. Any court should apply.
But the realism and rationality that I'm supposed to consider is coming from you, right? I mean, it's not me. It says the rule of collateral estoppel is not to be applied with the hyper-technical and archaic approach of a 19th century pleading book, but with realism and rationality. But the realism and rationality that you're asking me to consider and then accept is this idea that the jury found Mr. Valle not guilty based on the state's inability to disprove justification. So that's your argument, that's your realism, that's your rationale.
Yes, based on the case. And what I would like the court to do, even more, when I sit down and the state presents a position that says, you know, Judge, give us a second chance to retry this gentleman, and we have a good reason why we should do so, and we feel that we don't violate the law in doing so. I want the court to tell the state that they should apply realism and rationality and not an archaic approach. I want the court to tell the state that collateral estoppel in criminal cases should be applied in a rational and
Well, let's see what
way.
Mr. Durso's realism and rationality is before I even consider admonishing him that way. Chances are I probably won't. But I have four very quick questions for you, and the only reason why I'm asking, Mr. Crossland, is this is a judicial thing. So when a defendant files a motion to dismiss, and in your motion to dismiss dated April 15, you cite 8 different grounds. Actually 8.5, we'll get to the half in a minute. But you cited 8 different grounds in the April motion, and in the one from yesterday, May 31, you cited not an additional ground, but one certainly more involved, which is collateral estoppel. So you did not argue 3 grounds in the April 15, 2026, and I have to ask you now if you want to argue them or you're just going to rest on the papers, in other words. So in the April motion to dismiss, number 6, ground number 6, you said retrial is independently barred under Brown versus Ohio with the citation because the pending reckless offenses are lesser included offenses of the intentional charges for which Mr. Valle was already acquitted. Do you want to be heard on that, sir, or no?
Judge, I thought I was going to get credit for it. A lot of times judges say, if it's in the papers, you don't have to argue anything. I was highlighting the big picture.
If you look at me right now and say, take that on the papers, I will.
Yes, I don't want to belabor the court, Mr. Dershow.
I will take that on the papers.
I'm not abandoning any argument.
Okay.
And a PowerPoint, I want to be powerful, and I don't want to, you know.
Ground number 7. Dismissal is also warranted in the interest of justice pursuant to General Statutes 5456, as Mr. Valle was 16 years old at the time of the incident and has remained under the burden of a $2 million bond for nearly 4 years despite his 4 acquittals. That is a ground that you're citing for dismissal. Do you want to be heard on that, or do you want me to take the papers?
Judge, trying to take the papers.
All right. Number 8. The duration of these proceedings has caused substantial prejudice to the defendant, violating his Sixth Amendment right to a speedy trial under the factors set forth in Barker versus Wingo with the citation.
Yes, Judge, you can stand on the papers.
I will remind Mr. Crossland that Mr. Valle has never filed a motion for speedy trial, and there isn't one pending. So I don't know how I can consider number 8. I don't think that ground is properly before the court. In Barker versus Wingo, which is 407 U.S. 514, a 1972 case, in that case that you're relying on, the defendant had filed a speedy trial. Mr. Valle has not.
No, and I make the record clear, Mr. Valle has not. The court gave me a considerate amount of time to hire replacement counsel, who I am, which is me.
All right, but you're saying I should dismiss it because the courts have violated his right to a speedy trial. He hasn't filed a speedy trial.
No, so I'm not asking the court to make a ruling that the supports violating the speedy trial, but we can file one. I don't think it's prior counsel filed one either.
No.
But I just had to put everything in.
Finally, the half I referred to, it says, and you mentioned this in your PowerPoint, in the alternative, the defendant requests an evidentiary hearing to examine the trial record, including verdict forms and jury instructions, to confirm that the acquittals necessarily resolve the issue of justification. Now, you have the jury instructions. You used them this morning. I remember I personally made a copy of them before you in the presence of counsel. Verdict forms, there were no verdict forms in the underlying trial. So I don't understand your alternative request for relief that's an evidentiary hearing. What witnesses would you call during an evidentiary hearing if there were no verdict forms and you have the jury instruction?
Yes, Your Honor, thanks for that question. And just so the record is clear, Your Honor was graceful enough to make a copy of the state's motion, which I said I had received in the presence of the state. But Mr. Dan, who's an attorney clerk, I forget his last name.
Mr. Curica.
Mr. Curica was kind enough, his staff at least,
Always
gave me a copy of the jury instructions. And you did give me a copy of the state's motion, which I had received. But in terms of answering your question, as a catch-all, obviously my position is, as the court stated, you weren't at the trial, and if we are going to do anything shorter than dismiss this based on the constitutional grounds that I've articulated, I would think that the court may have to look at this, if the court's going to keep this, and have a hearing, have to look at who spoke, what they spoke. You said you didn't know if Mr. Valle stated that he did something intentionally. That's why I was saying we probably going to have to look at that.
But on a hearing, an evidentiary hearing, you're suggesting that I would, I don't know, that's why I'm asking you the question. I would listen to the trial record because there are no verdict forms, so there's no reason to have an evidentiary hearing on that ground. Jury instructions, I don't know who you would call as a witness to that. And you want me to examine the trial record. Just how do you suppose I would do that?
Examine the trial record?
Yeah.
Read the transcript. But again, if we get to that, if we get there, obviously we can strike some things that aren't pragmatic. But to answer them in isolation today, I think is probably not most efficient because as we do these trials, we have conferences and we decide what we're going to strike. But I have to put it all in today, and we can strike whatever we need later. But to answer your question, reviewing the trial record, we normally start with reading the transcript. For appellate purposes, when I take an appellate case, I spend $8,000 the other day for a transcript. It's a lot of money, and I have to read it. That's how I read the record, if that makes sense.
How long was that trial? You were on trial? Almost 3 weeks. I'll consider the request, but the request includes me reading transcripts on a trial that took almost 3 weeks for me to determine, A, whether amended information is properly before the court, which is a procedural issue, not a trial issue, and then I should search the entire record to determine whether collateral stop or double jeopardy applies. The big ask.
Yes, Judge. I'm ambitious in a sense, but I think that in that same ambition, I think that collateral estoppel, which is a part of double jeopardy, you don't have to read all those transcripts to look at this.
To settle the issue, I don't think I have to read any of them.
Yeah, I don't think so.
A very patient Mr. Durso, sir.
Thank you, Your
You
Honor.
can take as much time as you like.
Thank you, Your Honor.
And I will give you my undivided attention, just like I did to Mr. Cross.
And Judge, thank you for allowing me to be heard.
You're welcome, sir.
Thank you, Your Honor. As counsel just indicated that Judge Murphy did a great job with the jury instructions, and I just want to point the court to page 18 of the jury instructions where the court read to the jury, and this is, just to give you the court perspective, this was an excerpt from the latter part of the murder instructions to the jury. If you unanimously find the state has failed to prove beyond a reasonable doubt all of the elements of the offense of murder, you shall find the defendant not guilty of the crime of murder, and shall next move on to consider lesser offenses to murder below. If, however, you unanimously find the state has proved beyond a reasonable doubt all of the elements of the crime of murder, you shall next consider the defendant's claims of self-defense and defense of others. If you unanimously find the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or that the state has proved beyond a reasonable doubt one of the statutory disqualifications, you shall reject the defense and find the defendant guilty of murder. This will end your deliberations on count one. You will not deliberate on lesser included offense to murder. You will now deliberate on count two. If, however, you unanimously find the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defensive measures, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of that defense alone, you must find the defendant not guilty of murder at count one, even though you have found the elements of that crime proved beyond a reasonable doubt. This will end your deliberations on count one. You will not deliberate on lesser included offenses to murder. You will now deliberate on to count two. I read that excerpt to the court. As the counsel pointed out that the attorney did a great job with the jury instructions. I point that out because the jury was instructed as to self-defense and that it applied to all of the offenses charged as well as the lesser included offenses. The defendant asserted self-defense, and he's asserting that it was necessarily resolved in his favor, and the state would dispute that. The state opposes that argument. I believe during counsel's argument, he indicated that he wanted the court to look at the total picture, make inferences. Again, the jurors could not have considered lesser included offenses according to the jury charge unless they believed the state failed to prove one of the elements of murder, let's say, intent to cause the death, cause the death. We failed to prove one of those elements beyond a reasonable doubt. Self-defense never came into play there. And how do we know that? Because they went on to consider intentional manslaughter and indicated in that acquittal that we failed to prove an element of intentional manslaughter beyond a reasonable doubt. They never considered self-defense on intentional manslaughter. How do we know that? Because they went on to consider the lesser included offense of reckless manslaughter. And when they were considering reckless manslaughter, now of course, my argument applies to all four charges, Your Honor. I'm just simply using that as an example. They were hung. They could not agree. Did the state prove any of the elements beyond a reasonable doubt? And if they were hung on the essential elements of reckless manslaughter, just of course, benefit, the state had to prove, that there was conduct creating a grave risk of death, recklessness, extreme indifference to human life, and cause of death. They couldn't agree that, and we don't know, we can't speculate as to what element they believe the state, some believe that the state did prove it, some believe the state did prove it, but that's why they were hung. They never got to self-defense there. Because why? Because self-defense is not an essential, the objective, subjective standards of self-defense are not an essential element of the crimes charged or the lesser included offenses. Had they gotten to self-defense in this particular case, then they would have had to consider, after they found the defendant guilty of whatever charge they found him guilty of, they would have to consider whether or not we disproved one of those objective, subjective standards beyond a reasonable doubt, or one of the disqualifiers. That never happened. And that's where I think counsel's argument is misplaced. And again, I hate to beat a dead horse. I did file my memorandum, Your Honor, which kind of reiterates what I'm arguing today. But the point is, the verdicts of acquittal that the jury reached with respect to the greater offenses must have been reached by something other than self-defense. And we're presumed that the jury followed the court's instructions. And that's exactly what the instructions say. You are not to consider self-defense unless you first convict the defendant of one of those charges. Again, I read some of the cases that the counsel cited. He cites Williams, State versus Williams. Yeah, I would agree. Self-defense applies to reckless conduct. Absolutely. Which is why the court instructed that if you get to the lesser included offense of recklessness, you have to, if you convict, you've got to consider self-defense. Well, they never got that far. And one more point. Had the jury found self-defense, let's say on the murder charge, on the 2 assault, 1 charge is intentional, and the 1 assault 2 charge is intentional, we wouldn't be here today if they found self-defense. If they convicted on all those 4 charges, and they said, let's consider self-defense, the state failed to prove one of those objective, subjective standards, or failed to disprove one of those disqualifiers. It's an outright acquittal all the way down, and the jury instructions were clear as to that. I think think the crux of counsel's argument, unless I'm wrong, is essentially that. He wants this court to essentially find that based on the verdicts of acquittal, the jury necessarily found self-defense. Again, those elements of self-defense, we don't have to disprove them. We have to disprove them, but that really doesn't come into play until there's a conviction. So we don't know how the jury would have come out on that issue because they never deliberated. I agree with the court's interpretation of Yeager. Again, that case didn't even deal with self-defense, but here the state's arguing that we're allowed to go forward on this case on the lesser included offenses that the jury was hung on, because reckless conduct is one lesser included offense of intentional conduct, but we're required to prove elements that are not the same as intent to kill, cause of death, intent to cause serious physical injury, cause physical injury, dangerous work. There are different elements of those charges, so that's why we believe that based on that record we can go forward, because there are different elements of those 4 charges that we need to prove that were not part of the greater offenses. So they were part of the greater offenses, but those elements weren't, it doesn't preclude us from, that's why they're called lesser included offenses. It doesn't preclude us from moving forward on those charges because they're included in the greater offenses. The jury considered the intentional conduct. I guess we can all make the reasonable inference. Maybe the state failed to prove intent beyond a reasonable doubt. I know counsel indicated that the defendant got up there and said he intended to do this. I don't recall that in the record. I think the crux of the defense at trial was I had to react in self-defense. But that's not I didn't intend to do it. It's you acted in self-defense. Whether a jury bought that issue was never resolved. Obviously, we can't speculate as this is what the jurors found, but I think what we could reasonably agree on is that in order for them to even consider the lesser included offenses, they would have had to have acquitted on the greater charge before getting there. And that does not include self-defense. Self-defense, again, applies all the way down in this case. Had it applied to the greater offenses, we would not be here having this discussion. It would have been an outright acquit all the way down, including the reckless charges. And I think that's where counsel's argument is misunderstood, or perhaps counsel is misunderstood with regards to the application of the law in that respect. Touching upon, I know counsel asked the court to dismiss based on the grounds for speedy trial. I mean, the case happened, the incident happened in May of 22. 3 years later, we were having a trial. So he had a trial already in this case. It's not like we're unduly delaying this case moving forward because we're having this argument here. So I don't think that that's proper grounds for dismissal. Additionally, the defendant was released on bond by Judge Murphy. The state's position erroneously. He shouldn't have been released because the case should have just been put back on the docket on pretrial, and we could have had a discussion with regards to how to proceed from there. Instead, it was no next court date. Conditions of release were eliminated, essentially. So he hasn't been burdened with that in over a year, almost a year. So again, I don't think that that's good grounds to dismiss the case. I know counsel cites 5456, permitting the court to dismiss the case. Under that scenario, the reliance on 5456 in this respect, based on his argument, is based on overstated acceptably stemming from having to face a retrial. I reported State v. Alien 182, column 124 in our memorandum. Again, he's failed to identify any insufficient evidence for a cause, much less the existence of a compelling circumstance for this court to dismiss the charge based on 5456. So again, I read the memorandum initially filed by counsel. We had emailed counsel our memorandum back on April 27th. I did show counsel a copy of my email that was sent to his email. I know he put on the record here that he never got it. He did send it, so it wasn't we didn't not send it, is my point. So I don't want the record to reflect that we forgot to send it, failed to send it. We did send it. I don't know if there was an issue on his end of the email system, but it was sent, and I copied the clerk on that email, and the clerk indicated he had received it on the 22nd as well. Again, I don't know if the court goes outside the record to look and see whether or not the jury actually ever reached self-defense. I would argue that the media's been covering this case ever since day one, and I know that there's some footage out there of one of the jurors indicating they never got to self-defense. So that's where they point the court in that direction. If that's the case, then I think the defendant's argument fails as to why this case should be dismissed. With regards to whether or not this case is properly before the court, I submit that you do have a subject matter jurisdiction once again. The information that was filed in this case, right after the verdicts of acquittal and mistrial was declared on the lesser included offenses, was done to reflect the charges for which the jury could not agree on. And we did that so that there would be some charges that were reflected in the file. Do we necessarily believe we had to do that? I would argue not necessarily, because the charges were still pending. Those lesser included offense charges were still pending. The defendant was on notice of those charges when he was charged with the greater offenses. So for all those reasons, Your Honor, I believe that the motion to dismiss should be denied.
Just a question for the state. I imagine it's the state's position that the elements of reckless conduct, some of those elements are different than the elements of intentional conduct.
That's correct. And I touched upon that. I'm sorry if I wasn't articulate with regards to that. Absolutely, they are. But, reckless indifference, manslaughter, for example, we have to prove conduct creating a great risk of death, recklessness, extreme indifference to human life, cause of death. Those are different elements from intentional manslaughter, or murder. With regards to assault in the first degree, we have to prove conduct creating a risk of death, recklessness, extreme indifference to human life, and cause serious physical injury. Again, those are elements that are different from assault in the first degree intentional. And with regards to assault in the second degree, we have to prove recklessness, cause serious physical injury, the dangerous instrument. Again, those elements are different from assault in the second degree intentional. So, to the extent that I did not articulate that well to the court, that is the state's position.
Mr. Crossland, you asked for just a few minutes for rebuttal, sir.
Yes, thank you, Judge. Judge, I respect the counsel's position, and to the extent that they overlooked the crux of what needs to be proven constitutionally in order to go forward. I think that their resuscitation elements still fail to meet the high burden that must be proven in order to retry. With that, I would say that the state has articulated that the Honorable Judge Murphy may have erred on several grounds. I respectfully disagree with their position. I think she was very diligent in dealing with this case, very civil, and had a lot of judicial temperament, addressing both the families of the victim as well as my client, Mr. Valle. And I think that she erred in no way. And she did continue the conditions that was on, and the record is complete that she made no error. But counsel is entitled to his position if that's what it is. I would ask the court to strike any attempt, although it wasn't said with a deep breath, to reference what a jury might have said in some Hollywood setting in terms of where they reached in terms of self-defense. I think the counsel referenced that they might have some interview that I never saw, or some discoverable about a jury might have told some press about self-defense. I asked the court to strike that because that's not evidence. I think it's inappropriate.
I will not use any juror comments. They're no longer, they're discharged, they're no longer under oath. But I should also say, in your request of me asking to strike that one sentence that Mr. Durso said, the defense also sent me via email a portion of media where you had directed me to watch it because you said it captured your argument perfectly. So if you're asking me to ignore Mr. Durso's statement, I would tell you I have to equally ignore what you sent me in the email.
Which, by the way, I've never got a copy of that, so I don't.
I will only respond by saying two things. The portion that the court is talking about that I sent was also in my PowerPoint, and it was based on my motion, and it was shared with an individual who put that together and just posted on TikTok. So it's not media in terms of one crime or it was 12.
Well, it really was. I mean, if you ask, I did not look at it.
Okay.
But if I had clicked on it, with my limited ability to do those things, it was a media report that you said captured your argument almost perfectly. What's good for the goose is good for the gander. You're asking me not to consider Mr. Durso's one sentence. I'm not going to. But I also did not consider the email that you had sent.
And Judge, that's respectful. Obviously, as we spent the early part of the morning together and during my presentation, the bench was pretty hot. Not too many questions for the state, but 20 years of doing this, I've come to accept that. I hope the hot benchness wasn't of articulation that my arguments floored, and a cold bench, meaning no questions and no interruptions for the state, wasn't an endorsement of the state's argument. We could only fathom, again, like the jury, it's a secret thing. We don't know what your Honor's thinking. But nonetheless, I appreciate the hot bench, and I hope I answered the questions. And to be fair, as you're stating you are, I appreciate you pointing that out. I would go on to state's page 18 of the jury instructions, where the state states, when they read second paragraph, if, however, to the jury, Judge Murphy's charge, if, however, you unanimously find that the state has, in the affirmative, proved beyond a reasonable doubt all of the elements of the crime of murder, you shall next consider the defendant's claim of self-defense and defense of others. So when the state articulated that the jury had to have found Mr. Valle guilty of murder before they can consider self-defense, I think that's a little bit displaced. It doesn't work that way pragmatically. Obviously, they don't get to come out and say, hey, we found him guilty, now we can go in. They listen to all the evidence in the trial. They listen to the entire jury instructions, and all this is happening in real time, pragmatically. So my question to the court would be, if the state's contention is that it was a hard stop, something happened, then they went on, I would argue that can't happen that way, pragmatically. And so when the state says that you only consider self-defense if you convict, and that's their words. Pragmatically, what do you mean convict? The judge said, in your own mind, in your own deliberations, if you find that they have proved beyond reasonable doubt, then all the elements. And those are the same elements that exist for the charge that the state is looking to go forward on now. I have the substitute information, or the new information. The state's looking forward. They filed an information now in July stating assault in the first degree, and I believe assault in the second degree. The elements of those now new amendments are the same. And I pointed them out in the slides, 1, 2, and 3. Those are 3 elements: intended to cause harm with a dangerous weapon. Those are the same elements that they're going to have to prove in a new trial if they go forward. So the state is arguing that, according to page 18 of the jury instructions, that they must convict first. The language says if you find that the state has proven, then go to self-defense. And I think the state also highlighted that something of, we don't know what the jury had in mind when they reached these verdicts. I think we're all in that same space. But yet still they make their conclusion that they didn't consider self-defense because they were told not to. They absolutely were told to. They said, if you find that the state has proven beyond reasonable doubt, you can consider self-defense. Now, we don't know if they even found that the state proved beyond reasonable doubt that it was intentional. We just know the record says that if my client's defending himself with a knife, and that he testified that he did what he did in self-defense, then there was intentional. So with that being said, Judge, I think pragmatically, my only response as I get to rebut, as the state does most of the time, since it's my burden, or I go first, I would ask the court to to just be mindful that on reason and rationality and being pragmatic, the jury listened to everything, heard all the elements, and applied the law accordingly. And I do believe that the elements of the pending charges are the exact same elements that the state has to prove at the retrial. Thank you, Judge.
Mr. Durso, anything further from the state?
Nothing from the state. Thank you.
Thank you, Mr. Crossland, Mr. Valley, Mr. Durso, the staff, always great. We're going to give them a recess which they deserve. For the Part B, we will reconvene at noon. I want to thank the press corps for coming today as well. With the, I'll take it on the papers. So, let's give it a 90-day date, but I am extremely confident that I will have a ruling before 90 days.
August 28th, Your Honor.
August 28th, same conditions apply. Again, the decision will be a written decision, which the parties will receive. I anticipate having that decision much sooner than 90.
All right, thank you, Judge.
You're welcome. Thank you.
Court stands in recess.